with that, if it is that we're looking to increase or looking on the figure.
Yes.
Because practically 100,000, you're looking at calculations under 700 US, right? Am I correct?
Yeah.
So if you buy a MacBook, or if my wife was to buy me a MacBook Air or something like that, that's going to be required now to be declared?
Declare, yes.
I don't.
A good phone.
Or a phone. I think practically that you would have to look on increasing that number.
All right. So the committee then would suggest that we not close on a number, but rather suggest to our legislative team that the threshold be examined. And at a later point, I don't know, because you see, to pick a number out of the hat is really what is causing the difficulty now.
You know, I think we're focusing on the example used of a gift from a spouse. But let us say it is somebody who is, I don't know, issuing certificates of fitness. You know, a gift of 100,000 from many, many different people every day could make a huge difference to that person's income. So, you know, I don't think we use the spouse as a typical example. Somebody who is in the approval of routine permits, they may not even need as high a figure as 100,000. You know, so I think we spend a lot of time in the original bill discussing this figure, and unless we have some compelling arguments to change it, I would leave it in the current format. But I would suggest that on the other element of the recommendation of removing the exclusion of gifts from relatives, that we do that. And if you want to, if it is specific to your spouse, you're already obliged, or your spouse is already obliged to make the same declarations essentially as the parliamentarian does. So their affairs, their assets and liabilities and so on would have already been captured in the documentation before the Integrity Commission.
Yes. Okay, I'd like to suggest, members, that we recognize the recommendation to maintain Section 40, but to do the amendment to 44 to remove, yes, to remove 4.
No. Oh. Chair, having reread 40 sub 4, I don't think it's the entire subsection that would be removed, because I think you would still want to keep the first part, which talks about being able to exempt prescribed gifts. I think it's the latter part that the discussion was about personal gifts received by the parliamentarian from a relative. I think that is where you had that discussion. So it wouldn't be to delete the entire subsection, because you may want to have the flexibility to allow for certain gifts to be prescribed. I don't think that any have been prescribed. But is it that you think then that the discretion should not be there? Well, then you have to have that discussion, is what I'm saying, because you have only been discussing the second part of the limb, which deals with personal gifts received by a parliamentarian or public official from a relative of that parliamentarian or public official. You have not discussed the first part, which talks about it doesn't include such gift as may be prescribed. I don't know who prescribes, if it's the minister or the commission. But I don't think any have been.
Okay, let's talk it through a little more.
Things I'd like to put forward for consideration by the committee in respect of this section of content of a declaration. I think we should use the word declarant instead of parliamentarian or public official. I think we should standardly use the word declarant. Whomever is required to declare under the Act, the duties are such that if there is a carve-out for any one category of declarants, then that needs to be properly rationalized. But the fight for the quest for integrity in public life and the fight against corruption would apply to all category of persons. One. The other matter is that if the spouse of a declarant is also a declarant, I wonder whether it makes sense to impose the added burden for each to declare the asset of the other.
Yes.
For the declarants whose spouse is also a declarant, what is the advantage of having that spouse also declare the assets and liabilities, etc., of the other person who is a declarant and is required by law to submit a declaration? But you would have to get the information anyway.
I get two different declarations.
Yeah, but when you think of the administrative burden, no, again, it's not about the suspicion, because it appears that everybody is under suspicion, even those who would want to hold up their hands and give the appearance that they are not. Everybody is under investigation. I'm just saying from practical perspective and what we know already about even the administrative workability of a system where there is struggle to keep abreast with the assessment of the declaration, does it make sense? Perhaps the committee should deliberate.
Okay, so Member Robinson, let me hear you on that.
You may have a spouse in a joint declaration declare X, but on their own declare Y. Because they don't want the spouse, they don't want the spouse to know what I've heard.
For a different reason, we're talking
Okay, so let me rule on this one for now. I think we should hold this one for further discussion, having regard to the points that the SC actually made, the SG actually made. Exactly, among other things. So we move on to 41. Yes.
prescribed gift would be any category of gifts identified and prescribed. And when I last checked, no gifts were prescribed for non-inclusion.
Right. So we would ask...
So to the question, what are prescribed gifts? The gifts that would be prescribed by the minister to whom the power is granted to prescribe.
But it's silent on that.
The commission has prescribed any from your check?
No.
Right.
So where there's silence there in the provision, it is the minister who will have the responsibility to determine. The commission?
If I may, yes. Chair, Section 64 empowers the commission to make regulations prescribing any matter or thing in respect of which it may be expedient to make regulations for the purpose of giving effect to the provisions of this Act. So I suspect it would fall under that power.
Is the commission? Bye. Yeah. All right, we're still taking the position that we'll do a deeper look at this one and hold for the next meeting. Go ahead.
All right, section 41, starting at page 39.
A comment. Just when considering it, this talks about a relative, and relative is not defined, so it's ordinary meaning of relative, which includes not just persons related to you by blood, but also by marriage. That's the ordinary meaning of the word. So I'm just reminding the committee when considering what is contemplated here, that's part of it.
Yes. Thank you.
Okay, section 41. Jamaica Land's recommendation 41A seems to be saying that someone should file a statutory declaration at the end of the year if they had been holding office before the midpoint in the year, the end of June or the start of July. That is, someone should file a statutory declaration at the end of each year unless they just recently took office in the second half of the given year. It can be reworded for clarity and ease of reading. BSFM says, as it relates to Section 41 and the time of making statutory declarations, breaches of these provisions should be punishable by the imposition of daily fines for the period of delinquency. In addition to the existing liability for prosecution, demerit points can be accumulated to limit eligibility for service in the future. These can become matters which voters and political parties take into account when vetting candidates. If such delinquency results in automatic disqualification from political representation, the filings will be taken more seriously. The permanent secretaries recommended in relation to Section 41 that a forgiveness period for the failure to submit a statutory declaration and/or particular information stroke documentation in the statutory declaration be introduced in the Act. For example, this section could be amended to include a period in which public officials may notify the Commission of their failure to file particular information in their declaration and be provided with the opportunity to file same without being held liable to the offenses under the Act. In the alternative, the provisions could stipulate that where good cause is shown, the Commission may extend the period for filing a declaration by a period of 12 to 24 months. Oh, the first part, sorry. In relation to Section 41(7) and all of the sections relating to fines, it is recommended that a review of all fines referred to in the Act be conducted. It is also recommended that close attention be given to the fine and penalty associated with Section 43(2) and 56(3)(b based on the gravity of the Acts.
Chairman, on the last recommendation from the Permanent Secretaries Board, I can't support a recommendation for a forgiveness period. Now, once you have submitted, the Commission can ask you for additional information, yes, and you have time to provide that. But I don't think you should be given additional time beyond the 3-month period, which now exists at the end of the year, to submit, which is what I think they're asking for. So I couldn't support that recommendation. In terms of lands, I don't have the Act in front of me, but my recollection, I was first elected here December 29th, 2011, and I had to do a declaration having served for 2 days that year in 2011. I had to do a 2011 declaration. So I'm not sure what Lance was saying about whether it's half year. Once you are elected, whether it's for 1 day for the year, you're required to declare for that year. And as I said, I was elected December 29, 2011.
As a matter of fact, I think that the requirement...
There was an amendment?
Yes, it was amended after that.
To say what? Oh, okay.
Oh, yes. I remember that in 2020, yes. Yes. So really what they want to do is to take it back, essentially, to where it was. I don't think I will have a difficulty with that, no. Okay, 42.
Examination of statutory declaration and publication of summary declaration in certain cases. Integrity Commission says in Section 42(1) and 3, it is proposed that due consideration should be given to defining or clarifying the words, quote, examine, quote, duly completed, and quote, compliant. The reference clarification would remove any ambiguity on the part of the Commission and or its stakeholders regarding the declarations being complete. Additionally, in relation to the publication of the statutory declarations of the Prime Minister and the Leader of the Opposition, The form Part B should be amended to remove the requirement of the chairman to rectify a full declaration has been made to stipulation instead that a declaration has been made. Rationale, the terminology, quote full, would connote that the chairman is confident that all asset, liabilities, and income have been declared by the respective parties. All elements of the statutory declaration have been thoroughly interrogated, and that no matter requiring investigation or further action on the part of the Commission will arise. In the alternative, it is not prudent to have a third party attest to a full declaration submitted by a public official, having had no bearing or input into the preparation of the reference declarations. That's the Integrity Commission. The Jamaicans for Justice recommended that Section 42(3)(b) should reflect transparency and also to give credence to Section 3D. Furthermore, JFJ believes that being fully transparent will aid in enforcing penalties and sanctions. Rationale, in reviewing Section 56(1), JFJ is concerned about the high secrecy and confidentiality that statutory declaration of parliamentarians are handled. The fact that the aforementioned section does not apply to the Prime Minister and Leader of the Opposition subject to Section 42(3)(b), it is the belief of JFJ that all parliamentarians should be subject to Section 42(3)(b), which instructs the publishing of statutory declarations in the Gazette. Norman Manley Law School recommend that Section 43 require the publication of summary of the statutory declaration for ministers of government. Rationale, Transparency International has criticized the limited public access given to the information provided by declarants in their statutory declarations. Due consideration should be given to amending the section to require the publication of the relevant summary, Section 46(3)(b), for all ministers of government, as well as the Prime Minister and the Leader of the Opposition. Consequential amendment should be made to Part B of the third schedule of the proposed amendment is adopted. That is the 42, the Permanent Secretaries Board recommendations for Section 42. Time limits need to be included for the examination of the statutory declaration, as well as requests for additional information. It is recommended that a time limit of 2 years be set for the examination of the statutory declaration at Section 42(1) and for requesting additional information, subsection 42(2). Further, we propose that where additional information is requested, the Act explicitly specifies that such information shall be limited to the period within which the public official has held his or her office, and in cases where the public official is being investigated for breaches of the Act or allegations of corruption. There is need to strictly enforce the provisions of Section 42(3)(a) that states that where upon examination of statutory declaration, the Director of Complaints is satisfied that the statutory declaration has been completed, he shall cause to be issued to the public official or parliamentarian, as the case may be, confirmation thereof in writing, referred to in some jurisdiction as compliance certificate. See, for example, Section 13(3) of the Integrity in Public Life Act of Trinidad and Tobago, which states, Section 13(3), where upon an examination under subsection 1, the Commission is satisfied that the declaration has been fully made, it should forward to the person in public life a certificate of compliance. Isn't this now done, Chairman? Where, firstly,
I think, go ahead, Member Robinson, before. Did I?
Yeah, I support the Integrity Commission's recommendation because, in truth, there is some confusion in the terminology used. You get something which might say it has been examined, is compliant, and there have been cases where people receive that, feel that everything is good, but then later on, further questions are asked. So I think it is important to define exactly what each of those words mean. Does examine mean that you have been through it in detail compliant meaning you have satisfied yourself that everything in there meets your own understanding, etc. So the definition is needs to be explicit, because we get too many cases where the letter is issued and then follow-up questions are asked much later on down the road. I also support the recommendation about the removal of the word full, that is on page 40, in relation to the Prime Minister and the opposition leader, because I do agree that full gives the impression that it is a complete declaration, and they may not be in a position to say at the time that it is a complete declaration, because they haven't done all the analysis to determine that. But once you say full for the public, and certainly for the declarant, you would assume that you are okay. So I support the Integrity Commission's recommendation. In relation to what the Permanent Secretaries Board recommends, that it should only be limited to the period for which the public official has held office. I don't support that, because it is possible in the scope of your investigation, the Integrity Commission, that they may have discovered things, you may have been in a different post or something, and I don't think they should be restricted from further examination of your overall records if they believe it is pertinent to an investigation that they are currently doing in terms of corruption. Meaning there may be issues that may arise once you start investigating. Let's say the person is now a member of parliament, they may have been a councillor before or another official, and there are issues that arise from the previous one. The Permanent Secretaries Board is basically saying it should be limited to the post you hold now, and I don't support that.
No, I think, Chairman, there has to be a limit, though. There has to be a limit in terms of how far back the Integrity Commission requires information. Furthermore, once they have signed off some form of compliance, then one would assume, I must admit that I get it every year, but there was 1 year where they asked about 2 companies of which I was supposed to be shareholders 20 years ago. I wrote them, I never heard of these companies. But when I really checked, it was 2 companies my office formed, which was the normal thing, that you form companies that your clients take over. And when I checked, in fact, they were in the archives. And I had to go and get them out of the archives and spend money to have them closed because they never had any transactions. But that is almost 20 years after that I had to go back and check on those. I did not have any idea. And I'm saying, Chairman, that various allegations, put it no stronger than that, have been made by parliamentarians and by public officials, including what the permanent secretaries are saying, that they're going back to investigate matters which occur decades ago, properties that they probably had acquired decades ago and probably sold. And the question is being asked, how much did you acquire for the property? How much did you sell it for? And, you know, it just seems that there has to be a limit, just like the statute of declaration for, say, civil matters. I don't think that once they're signed off on your statutory declaration, or for that matter, 7 years have passed, or even 10 years, that the Commission should be asking for further clarity or further information. And I'm saying, Chairman, I say nothing more than anecdotal because I can't confirm, but there are parliamentarians now whose statutory declarations have not been certified because they're asking questions about transactions long before they became parliamentarians and decades ago. So, you know, Minister Robinson, I would say there has to be a time period. Say, I don't know. Many people after 10 years may have thrown away all their statutory declarations. Suppose they go back and ask things beyond 10 years. Is it appropriate? Which I know, or I believe, is happening now to parliamentarians, where they're asking questions now about accounts that they had more than 10 years ago, which have been closed off. And my understanding is that because the Integrity Commission has been able, over the last 2 years or so, to get information from banks, from the National Land Agency, from various sources, that they are now asking questions because this information is now available. And I don't think it is fair, because the people, basically, accounts have been closed, transactions were completed, and now to ask after a decade and more about these transactions, it is really causing a lot of public officials to wonder, what is it that is being asked of them?
Thank you, Mr. Chairman. Mr. Chairman, it appears to me that we perhaps need to focus on what the Permanent Secretary's recommendation was in relation to, it was about limiting the relevant period to the period in which the public official has held his or her office. That's the language that's quoted here in the matrix. In my understanding of that, it would be whether that public official held public office in different roles, whatever that period was, that would be the relevant period. The period prior to the public official becoming a public official and subject to the Integrity Commission Act would sit outside of that. So once we're defining that it is in relation to the years of public service, then that timeline runs from the point at which that public official is elected or appointed, and that's the relevant period. So that the difficulty of a private citizen who doesn't perhaps, like myself, anticipate that they will enter into public service, having records from 1985 or 1995 or whatever far period you want to say is a period that is now being used to request information from persons, that wouldn't arise. The relevant period would be the date of appointment or election onwards. And I would imagine that the Integrity Commission would only be interested in the period prior to that if somehow there was some issue on the very first statutory declaration or on subsequent statutory declarations that required an explanation that predated your appointment. So, for example, you know, in the case of, let us say, and I'm using a very hypothetical situation, let us say at the point of your appointment, like Member Robinson, you come into office a day before the end of the statutory period. You have to file a declaration by March 31st. You file the declaration, but you leave off an account that is dormant that maybe you haven't used in 5 years. You don't remember it, you're not thinking about it. Subsequently, you begin to use it. You reinstate that account and you begin to use it. But you haven't declared that it existed, and it existed long before that statutory period. I mean, it's something like that, and I hope I'm not complicating the example, but it's something like that that I would imagine would cause the Integrity Commission to want to inquire into the period prior to your appointment. But other than that, this act is supposed to govern public officials. Public officials only become public officials on appointment or election. So I don't agree that there should be wide access to your period of private life unless there is something else, something that the Integrity Commission can show requires that or makes that a justifiable extension into your private life. With respect.
Oh. Chairman, may I be reminded what exactly we are discussing? What specific recommendation? Section 42 speaks to the examination of statutory declaration and publication of summary declaration in certain cases. One speaks to the duty of the Director of Investigation and Complaint to examine or cause to be examined every statutory declaration that is submitted in order to ensure it complies with the requirements of the Act. Two speaks to what happens upon examination where the Director of Information and Complaints is of the opinion that further information is required in respect of the statutory declaration. He is empowered to request that the declarant submit such other information as may be specified in the notice. And there is a duty imposed on the declarant to submit the information that is required within a specified period that would be set out in the notice. Then 3 speaks to the duty of the Director of Complaint and Investigation on examining the statutory declaration. Where he is satisfied that it has been duly completed, then he shall inform the Commission, and the Commission shall issue the public official confirmation in writing. And notwithstanding that, the publication of the Leader of the Opposition and the Prime Ministers. So the Commission is asking for some clarity in respect of what is to be issued to the declarant. And I'm really asking that parliamentarian and public official that we standardize and just refer to declarant, and we know the duty that is placed on a declarant, because the declarant has to comply with the requirements of the Act. So my understanding is that they're seeking to avoid any misunderstanding about what it means when the declarant is issued a confirmation in writing that their declaration has been received. Because they don't know whether it's complete, it's full, it's just that it has been, the statute has been complied with insofar as the submission of the declaration. And I think that that is a reasonable ask from the Commission, and I would be inclined to support that request for the clarity to be provided. The other part of the discussion appears to me to be about what should or should not be requested of a declarant. And I would say it may be helpful to consider that upon examining a statutory declaration, some things may appear unclear. And a declarant should not, the Director of Information and Complaints does have the duty to request any information that would bring clarity to a declaration. I think instead of viewing it as so burdensome, the explanation may be a simple explanation, as the one provided by Minister Chuck by way of example, that at a certain period of time, the practice was standard for attorneys in providing their service to the clients, to open, to incorporate companies and be listed as interim directors. And sometimes, depending on what is done by the client, different steps may be taken, and it's a mere omission. So instead of seeing it as so burdensome, I don't think it's unreasonable to inquire whether the directorship still exists. But your explanation may dismiss the suspicion that there is anything untoward. And all declarant, I think, instead of going into this fight We have to understand that while you are in office, if something triggers a suspicion, it doesn't mean that the suspicion leads to guilt. It doesn't mean it leads to something. You just need to provide the clarity. In other cases, it may be a little more difficult. But if an offense is committed, as a standard rule, time does not run against the Crown in prosecuting offenses unless it's a statutory offense and the statute creating the offense prescribes a limited time period within which the prosecution is to take place. And if the time passes, it becomes statute bar. But it's also not helpful for the approach that has been taken. I think it's the approach as to how far back one goes, bearing in mind that people may not keep records. But we must also be mindful that conduct by persons in former positions may impact the approach they take currently. And so I don't know that it should be a hard and fast rule to say that if you were in a former role and questions arise on the examination of a declaration, you should not be asked to provide the information. It has to depend on the circumstance. It has to depend on the matter being investigated. But no. I believe Member Golding made reference to your only becoming a public official upon taking up the role. But I think it may be more helpful to look at it from another perspective. You are required to submit your declaration. Having submitted your declaration, something requires clarification, and clarity is sought by way of a notice specifying what it is that you're asked to submit. If it is that what is asked of you relate to a long time ago for which you have no record, or you never thought it important to keep the record, or like me, periodically after 7 years when the tax period for keeping record passes, you throw them out. I mean, that's a proper explanation. You supply the explanation. If that does not suffice, then there is nothing that you really can do, because you can't produce what you don't have. Bottom line.
Leave you in the investigation.
Like I say, Chairman, all things depend on the circumstances. I don't know that we can, on examining a declaration, questions arise, the Director of Information and Complaint is empowered to seek additional information, and the declarant is under duty to provide the information. The offenses are created, have the term without reasonable excuse, etc., etc. Ultimately, it would be a matter for a court to determine whether an excuse given is a reasonable one, to determine whether an offense has been committed or not. If the investigation is towards prosecution, it may be towards something else.
I just wondered what the duty of the law is in this regard, whether it should be so open to enable,
if we look on,
you know, what could very well be an abuse
Chairman,
of the individual.
The offenses that come in relation to the statutory declaration, which are set out at the following section, 43, a person who knowingly, because you can unknowingly make a statement that is incorrect, and it can be for error or otherwise.
Just an oversight.
Right. Knowingly gives a false information. It's about the knowledge. Yes. Because a crime has the coincidence of actus reus and mens rea. You can do an act which is wrong, but there is no mens rea. You can have the intention and you don't do the act. And all of the offenses, a person who fails without reasonable cause to submit, a person who fails without reasonable cause to provide an information. It is reasonable cause not to provide it if you don't have it.
Right. I think those are the issues. I think these are very clear, and we appreciate that.
That's why I began by asking what exactly were we discussing.
Right. I think the point that Member Chuck was making in relation to time is of some importance that we should look at. In other words, how far back in time do you go, and how relevant would those things be to the current situation? And in fact, who determines that in the end?
Mr. Chairman, I understand that I'm sympathetic to the example Minister Chuck made. However, if we look globally, look at heads of government and states and senior ministers who have been successfully prosecuted for corruption. It is usually after they have left office, because while they're in that high office, they can often protect themselves from prosecution. In fact, some have explicit immunity for the holders of the office. So it is invariably years after they have left office that the evidence comes to the surface. And if you therefore put a statute bar on it, then you'll make the likelihood of such prosecutions very remote. So I really don't believe that you should have anything similar to, say, the tax authorities, who I gather can't go back further than 6 or 7 years, whatever the figure is. I'm saying that.
The question is, what was the purpose of creating in the first?
No, but I'm saying what
statute bar.
No,
just for the purposes of understanding.
No, I'm saying it's two different situations. Senator Golding said that. Golding Campbell said that she doesn't believe the period should go prior to your first holding public office. But that's a separate issue from the one that Minister Choko is making, which was he has been holding public office for a long time. So even the 20 years, he would still have been a public officer. And he's saying, but because of the passage of time, yes, he shouldn't be required to have all those records. But I'm saying that as regards Minister Chuck's point, I'm saying because the reality is that if you are a holder of high office in a country, you can probably use that very position to protect yourself. And as we have seen in the past, not just in Jamaica, but globally, usually prosecutions occur after people leave office. So if you set a statute bar, of something similar to tax, for example, then you would be very unlikely, or in many cases, you'd never have such prosecutions. So I don't support that statute.
When you legislate, do you legislate for the exceptional, or do you legislate in relation to what is the norm? In other words, do you legislate for that 1% or 2% who may slip through, or do you legislate to protect all?
I'm not sure.
Yes.
Okay. I had another point, but just before I shut off my mic, this issue about the concern that the terminology full would connote that the chairman is confident that all assets and so on. I think that can be easily solved. That by just changing the wording, something to the effect, and the Solicitor General can better advise, but something to the effect that on the face of it, it is satisfactory. Because something may always arise at a later point, something that was omitted from the declaration, for example, which would cause them.
I think that's the intention here.
So, I think that can be easily resolved. And I support the Integrity Commission's recommendation.
I would support that too in terms of the state of the declaration, in terms of certification of it. Mm-hmm. Whether it is full certification, what does that mean? Or it is certification to indicate that you have complied in so far as the requirements are. However, it still leaves them the option to look at anything else that may come afterwards.
Let me just respond to Member Bunting. First of all, virtually all crimes are not statute barred. So once you've committed a crime, if you did it 30, 40 years ago, it could be investigated. What I'm concerned about is in terms of the Integrity Commission asking you questions beyond, say, 10, 15 years, or even before you became a public official. Because I just think it is quite invasive. And quite frankly, I think it was the Solicitor General, Ms. Aldred, who has pointed out, that a lot of the information that the Integrity Commission is asking for, really, they should not, because it's an invasion of privacy. I forgot the case, SG, that you said the Privy Council ruled on a case from the Turks and Caicos, that some of the information they're asking you about matters in your bank account or your private transactions, that these are matters which don't touch on your role as a public official, and therefore it is quite invasive. And it is something I must ask the SG for that case again. I need to read it because I think it is quite relevant, because a lot of the questions that I know parliamentarians are being asked may well be inappropriate and unlawful according to that Privy Council Act. Am I right, SG?
Well, at the time I was trying to make a distinction between the manner in which the Integrity Commission exercises its powers, and I think if they are acting under their power to request information by the Director of Information and Complaints when he is reviewing the statutory declaration that is submitted, I think that's one thing, and it should not be confused with the powers that they have that can be exercised by the Director of Investigation. So what that case was trying to say was what the Integrity Commission would have been doing was more under, should have been done under their powers of investigation and not done when the statutory declaration is just submitted and you're talking about a verification process. So it's a matter of how they undertake their functions then. So for instance, there are times when the Integrity Commission will write back to a declarant and indicate that they need more information. But depending on what they're asking for and depending on how they're going about it, it may not really fall under their powers of verifying a statutory declaration. It may really fall under their powers to conduct an investigation. And those are done under different sections, and they have different powers that which they must operate on under in different sections. And from my perspective, I've seen some examples where it's kind of questionable whether there is some overreach when they are doing the verification of a statutory declaration, which looks more like an investigation.
Exactly.
And the thing is, if you're conducting the investigation, you're supposed to operate in a different manner. So the person, say if you are going to summon the person to come before you, the person should then be made aware that this is really an investigation and not that you are doing some verification of a statutory declaration. And so the case from the Turks and Caicos was sort of along those lines, because what the powers, their Integrity Commission was doing was not just getting information from the declarant, but also going to the banks, a financial institution, for instance, and requiring the financial institution to provide information. And at the time, if it's not an investigation, I think what the Privy Council was trying to say was, and this was going a bit beyond their powers.
Absolutely.
So, Chairman, this is a matter, I believe, that should be deliberated upon by the Oversight Committee also, because how the powers and duties are discharged will go a long way in the confidence that is reposed in the entity. And I think, I think in parallel to the criminal law process, where the police are doing a question and answer with a suspect, with someone. The moment the answers reveal that the person becomes a suspect, you have to change the approach. So once you become a suspect under the judge's rule, then they have to be told their rights, that they are not obliged to say anything, and anything said will be taken down in writing, shall be taken down in writing and may be given in evidence. I think that clarification perhaps is the bane of contention in how the Integrity Commission operates. And if you look at how the entity is structured and the so-called Chinese walls that should exist between the directorships, if on the examination of a statutory declaration, suspicion rises to the level where it requires an investigation, then it is not simply a matter of requesting information from the declarant, but advising the declarant of the nature of the suspicion and that the matter has become a matter of investigation. And I think that is where the problem lies, the approach taken.
Can I just question? Is there anywhere in the law where it requires the Integrity Commission to inform that individual once you have passed that threshold from examination to investigation? Does it require it to do so? Because it then affords the declarant an opportunity to engage counsel or whatever, or it doesn't?
From my recollection, it doesn't say, but what I do know is when they are summoning persons before them, usually it's done by a specific director. The ones I'm more familiar with is when the Director of Information and Complaints summons persons, public officers, to explain certain submissions. So for instance, quarterly reports. If they are not submitted on time, what the Integrity Commission does is sends out a summons for the head of the entity to appear. And it's clear in that summons that it's done by the Director of Information and Complaints, but when you look at the law, the Director of Information and Complaints operates in a specific manner, and it's in relation really to information and complaints. It's not supposed to be an investigation. So if it's going to be an investigation, that summons should have really been issued by the Director of Investigation. But we just noticed that there are some matters where it looks like it could likely be an investigation, but you're not going to know.
So, Chairman, from my reading, and please do not take it as a complete reading at this time, I do not see any provision relating to converting an examination of a statutory declaration into an investigation where additional information is required. The law speaks to what happens when a complaint is received by the Director of Information and Complaints and passing that over to the Director of Investigation. But the part of the law which speaks to the investigation really goes straight into the findings of the Director of Investigation on the completion of an investigation. But I think, Chairman, this really may be where the problem is, the gap in the law and the approach taken, because the natural justice elements would not be satisfied. It's almost as if it could have the appearance of not a sting operation. There is a term that escapes me in the moment. Entrapment. Yes, yes. But you see, the processes and the approach taken must itself have integrity. Must themselves have integrity. And so if it is that the request for further information is being done under the guise of an investigation and the declarant is not informed of it, then something would be wrong in that process. And I think in our review of the law and having regard to concerns that have been raised by declarants, not only within the parliamentary group, but others, I believe that is an area that needs to be addressed. So a provision ought to be made in the law where on the examination of a return or after requesting information, it appears that an investigation is warranted, then the declarant is to be notified that the matter has moved from a mere review of the declaration to an investigation and what their rights are in those circumstances.
May I propose we defer this section and ask the Solicitor General if she could circulate that case, Turks and Caicos, to members? Right, I think when we, send it again so we can read it, and it would give us a better perspective of how what proposal we could put forward in relation to this section, Chairman.
Well, I would perhaps go one step further in regards to requests of the SG that perhaps she researches it a little bit more and give us some guidance, because I think that this one has really occupied our minds a little bit, and that there are quite a few areas that we need further guidance ourselves on. Not all of us are lawyers, as you know, and it would be useful indeed for the guidance. So, Madam SG, yes.
Chairman? Chair, I'm about to throw my colleagues under the bus and perhaps back up again as well, because don't you think this is perhaps more for the Legal Reform Department than the Attorney General's chambers?
I see guidance from the two members who are competent to deal with that.
The committee is requesting advice from the chambers, yes. Madam Solicitor General.
Oh, it's very important.
Not for... Anyway,
well,
we'll help the chambers.
Yes.
Mr. Chairman,
my ministry will assist the chambers in this regard.
What advice are we really asking for? I just want to be clear.
Well, whether there is a provision for, within the law, to protect one from this seeming seamless transfer from investigation, from
information verification to investigation. Because
and what protection would be available.
I mean, it occurs to me, you know, when the police are investigating a potential, a suspect, let us, or doesn't, I don't know if it rises to the level of suspect during the investigation or at the commencement of the investigation, but you don't necessarily know who and what the police are investigating until they call a person in for a question and answer session. So I too am a little gray about what exactly ought the position to be that is consistent with other law enforcement authorities and also balances the rights of the declarant who may then become a suspect. But I just also want to say in relation to Minister Chuck's statement, and I thought Senator Bunting had cleared it up, but I don't want us to obfuscate it. My point about being able to ask for additional information in relation to a statutory declaration prior to the date of appointment or election to public office, and what I think intersects with what Minister Chuck is saying, which if you have been, for example, a public office holder for a period of 20, 25 years, in my view, that's a relevant period that you would want to keep records of. And I do think that in the public interest, the public ought to be able to know about your declarations and your conduct of yourself and business during that time. Minister Chuck is saying we ought to have a time limit because day one, 20 years ago, you may no longer have records. But I think we may want to consider whether or not public officials ought to have the duty to keep those records during that time of public service. And I'm just making the distinction between that and when they were private citizens and then became public office holders.
I think there is a further dimension to that, which might not have been said, which perhaps we could get guidance on, is whether or not in a previous period, under a previous dispensation of statutory declaration requirements, your declarations were made, approved, certified, and then years after, exactly. So I think some guidance too is needed on that, yes.
If I may, the need for clarity in the law becomes even more important when one considers that under the part of the law dealing with the powers and procedures in respect of investigations generally, there is an explicit provision that no person shall, for the purpose of an investigation, be compelled to give any evidence or produce documents which are subject to legal professional privilege or which he otherwise could not be compelled to give or produce in proceedings in any court of law. And also that nothing in the section shall be deemed to remove the right of a person against self-incrimination. These are top rights guaranteed. Right, that's what I'm saying. So the issue cannot be looked at in isolation, that it is one thing to examine the declaration, but it's another to request the information when the examination has proceeded beyond an examination into the realm of investigation. And I think that the statute should expressly give guidance to the Commission and the directorships when the examination of a statutory declaration transcends to an investigation, what procedures need to be applied in those circumstances. Yes, and it is something that we may have to standardize because, Mr. Chairman, the charter provisions bind all parts of government and all public authorities. And we really have to review the laws in light of those provisions, which the constitutional review process will not change. We will tidy up language, but insofar as the binding nature of the charter in that regard, it's not going to change.
Okay. I think...
Next point.
No, I think that we've really exhausted the discussion on this. And the guidance that we have asked for.
Having exhausted that position, we're exhausted, Mr. Chairman. So I strongly suggest the remaining sections are minor, if I might say this, and it can be completed in another session. So I would propose that we adjourn at this time.
Right, but just before we go, I think we could accept, in essence, the recommendation with regards to the nature of declaration, how it is defined, full declaration versus...
No. I have no problem.
So that element of it, I think we can accept.
So may I propose with my colleagues that we adjourn at this time, Chairman, and resume at a later date to complete. The remainder is fairly straightforward.
I think we have about...
You can finish it, or if you go straight, or you finish at 4. But
how many? I think it goes 64.
I doubt it. You need another hour or two.
Let me give you that information, because we really want to complete this within this side of the fiscal year.
We could do it one day morning next week if you're around, Chairman. I need...
The problem we have is the number of committees that have to meet in the one chamber, and the same staff, particularly the Hansard, that is there. So when we do get our moment, we have to use it to the full.
If members are willing, we could meet on Friday.
Friday is not difficult.
But yeah. Anyway.
Right, so based on the number of sections that we have in this matrix, oh yes, no, we have about 14 more sections to go. And at the rate of where you're going, you're right. But I think that as you go further down, you will see less controversial areas, and we'll be able to cover. So we're going to adjourn for a date to be fixed. Yes, indeed. So we will, on the motion of Member Chuck, seconded by Member Bunting, we will adjourn for a date to be fixed.
Are on, and PBCJ is the place to watch them. See students from schools all across the island match wits and tackle complex issues affecting our nation. Watch as future leaders and thinkers solve problems with innovative arguments. Tune in on Mondays and Thursdays at 5 p.m. with a repeat on Saturdays from 1:30 to 3:30 p.m. Watch the National Tourism Debates on PBCJ, the People's Station.
Here is a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5.
Every father should remember that one day his son will follow his example instead of his advice.
That was a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5.
It's Tuesday, January 9. In the headlines, Jamaica Teachers Association and the government agree on outstanding compensation. In business news, the Caribbean reaches all-time high in hotel performance. In regional news, Belize receives over $3 million for climate resilience projects. And in sports, India donates 100 cricket kits to Jamaica. This is the news on PBC Jamaica. I'm Simone Absalom Gale.